Start the morning with arguments in State of Ohio versus Chad Henning, case number 29128. Both parties are represented for the hearing here today, so each of you will have 15 minutes to present your arguments. You probably may reserve up to 5 minutes. If you're going to reserve time, Attorney Williams, just let me know, and I'll actually, we've got the clock on the wall now, right? So, but I'll also try to remind you. I'm sure you both know that we do record the argument, so please stay at the podium, keep your voice up so we get a good recording for the viewers. And we've read the briefs and are ready to proceed if you are. Yes.
Good morning. May it please the court, Ms. Corrigan. I'm going to highlight a few points. I know this court is very good at reading the briefs. There are 3 assignments of error. The 3rd assignment won't be addressed. The manifest way of the argument is it is what it is, and I can't say any more than I said in my brief. Obviously, I want to focus on the 1st assignment of error, because if Judge Gallagher, trial court, had granted the motion in limine, we wouldn't be standing here today, because there would not have been a trial, and all the other things that happened wouldn't have occurred because the trial would have been short-circuited. That body cam of Officer Lagasse, it showed a woman who was in distress. However, as cited in our briefs, just because you're upset or excited or nervous or gone through a horrible experience, there's one of the cases where the woman came running out of the house in a t-shirt and was breathing heavily, was extremely distraught. I think that's State v. Scala, and the court found that the statement that she wrote out was a intentional, deliberate reflection of the facts, not an excited utterance, and her statement was excluded. Lena Riley didn't even come close to that type of state of mind. It was 2 hours after the call had been made, so it's clearly, there's no dispute, it was not an emergency situation. I believe if it had been, law enforcement would have elevated that to make it a higher priority. So they must have felt that it was not an emergency. It was 2 hours later. She was still upset. There was evidence of something happening to her, but the alleged assailant was nowhere to be found. Officer Lagasse did not check into anything there. And the whole body cam is basically, is she going to write out a statement? Is she going to allow charges to be filed? And eventually she does write out a statement, and he tells her what's going to happen. Within minutes, I don't know the exact time, but within minutes, she's calling the police station recanting. And that type of conduct was throughout the trial. In my motion in limine that I argued at trial, I was able to relate to Judge Gallagher that she had showed up at arraignment, she had showed up at the pre-trial, and said, I made a false statement. I made a false statement. She wanted to recant.
Counsel, can I back up?
Yes, Your Honor.
Your statement that it was not an emergency situation because it apparently took the police, for whatever reason, 2 hours to respond to the 911 call. Does that argument go toward the fact that it was not an excited utterance, or does it go toward your contention that it was testimonial communication, or both?
That's a good question. I would believe it demonstrates that it was not an excited utterance. I think my argument on the testimonial nature of her statement was more how the interview between Officer Lagasse and Lena Riley was structured. I think it took it out of the excited utterance, so I would focus on that.
Of course,
Ms. Callahan.
there is no per se time limit after which a statement can no longer be considered an excited utterance.
That is true. However, it's still a factor to be considered. Just because it was 2 hours later, if that was my only argument, I wouldn't have an argument. I think it's something that must be considered when you put it in the totality of the circumstances. It was 2 hours later. She had been consuming alcohol, and I believe, she had.
Was this a situation where she was questioned in any way prior to the statement? In other words, did the police officer elicit the statements, or did she make the statement in the subset?
She asked what he comes in and he asks, what had happened, and tries to calm her down, and then he focuses upon, okay, what happened, who was it? And it was clearly structured as a, I'm getting facts for my investigation, and he makes a decision. I am going to file charges. And she knows that right off the bat, that charges are going to be filed. So I think he put it into the fact that it's going to be a criminal situation, and he's making sure that he gets the statement from her, the facts, because no matter what she says or did, those charges were going to be filed. And I think he well knows, and I'm not impugning him at all, he was a very experienced officer, but they have to deal with this all the time. And I think they have to, in the back of their minds, preserve the evidence in case there is a recantation at these domestic violence trials, so the prosecutor can go forward with the information as the event happened.
But in terms of his questioning or how he questioned her, or whether it was, for purposes of later prosecution, in this particular case, does it matter? I mean, he had his, not even a right to confrontation. She testified on his behalf.
Yes, and my opponent wrote a devastating brief on that point, which I complimented her in an exchange that we had outside the courtroom when we just happened to meet. But my argument is, that was a decision that turned out badly for Mr. Henning to allow her to testify, trial error. I had advised him against it, but my point is, if the body cam of Officer Lagasse had not come in, if the motion to eliminate had been granted, we wouldn't have had to make the decision of, she shows up on the third day of trial and says, now I want to testify.
But that goes to the excited utterance argument.
Yes.
Okay.
I believe that whether or not Appley wins the case is going to be whether or not you decide whether it's an excited utterance. I believe that it was testimonial, not just an excited utterance under Washington v. Davis, but that branch of the argument is not as strong. It wasn't a structured interview. He wasn't writing things out, but it was, again, I believe it was, the answers that she gave were reflective. She had had time to think about it.
Of course, this is an abuse of discretion standard. Yes? On
a strict motion to eliminate whether to allow excited utterance, it's abuse of discretion, but the branch of the motion as to whether or not it affects his right of confrontation under the Sixth Amendment would be.
Strictly, I'm talking about the excited utterance part.
Yes.
And the court I'm assuming the court viewed the body cam.
They did it in camera after we made the argument. I don't remember the timing of it, but I know that Judge Gallagher said, I'm going to look at it. The next morning, he came in and announced his decision, and we proceeded with the trial. The second, I'd like to turn.
Before you go there, let me pause this for a second. Were you reserving time?
No, Your Honor.
You're not, okay. You've got 7 minutes.
I'd like to spend my remaining time on the second assignment of error, and that is letting in the jailhouse calls of April 17th and 18th. Prosecutor D'Angelo kept saying we're not doing it for forfeiture, wrongful conduct by forfeiture on 804B6, but that's clearly what it was. I mean, you can say it wasn't, but a rose is a rose is a rose. He wanted that testimony to come in as to why Lena Riley wasn't there. He wanted the jury obviously is thinking, why isn't the victim here? And if the alleged defendant is telling her, don't show up in court, the case is going to go away if you don't show up. And that's what's discussed on the tape. There's no admission on the tape that he did anything to her. It's just don't show up. Then that is forfeiture by wrongdoing, and the rule is very strict that there has to be a notice of intent to use that, which the record is clear. There was no intent filed prior to trial. There's also argument that, well, I'm not using it I'm using it for consciousness of guilt. I think that's just calling forfeiture by wrongdoing by another name. He also says that they're not excited utterance, which I don't understand. I was reviewing that in preparation this morning, and I don't know how excited utterances even gets into the discussion in the conversation between Mr. Henning and Ms. Riley. It's just, I think he was perhaps grasping at straws as to having those tapes come in. The other part of the prejudicial factor of allowing that is it takes things out of context.
Wait a minute, I have to back up to your forfeiture by wrongdoing. The forfeiture by wrongdoing, I understand why you're saying that, but the state would have to, according to the evidentiary rule, and I only know this because of another case today, not because I'm so great with evidentiary rules, that would go to the victim's statement. In other words, if the state wanted to get the victim's statement in, they would have to give you notice of, they want to do it via forfeiture by wrongdoing. You're asking for you're saying you should have gotten notice under the forfeiture by wrongdoing for the jail calls, is that your argument?
Yeah, I mean, it's her statements, that were also on that tape.
Because she was the other person on the phone.
Correct. I'm not an expert on the rules of evidence as well, Judge Callahan. I believe that my understanding of the rule and how I apply it in my trial practice is if you're going to use a statement of a defendant against him as some type of admission, because the purpose of that rule is if you're interfering with the judicial system and having the victim not show up, that fact can't come in if you're doing so wrong, if you're telling someone not to show up. And that's what that tape was played for, was she's not here, I don't want you to show up, this is my get out of jail free card. I guess at this point I would ask if the panel has any more questions about the arguments that I've made.
Judge Kelly? You want to reserve 3 minutes?
I'll reserve 3 just
Okay.
in case Ms. Corrigan says something that I feel I need to respond to.
All right,
Thank you.
let's reserve 3 minutes then. State has 15 minutes, obviously.
Thank you very much, Your Honor. May it please the court, counsel, good morning. I'm Jacqueline Corrigan on behalf of the appellee of the state of Ohio.
I just pause this for a second. Can I just notice that the clock is not working? Fair reason. Oh, now it is. Okay. There you go. Whatever you did, don't sit down. I'm sorry to interrupt you. Go ahead.
That's all right, it's technology. We know how that goes. Regarding the appellants versus assignment of error, the state really has 2 arguments. That the appellant is arguing that the victim's statements were not excited utterances under Rule 803-2. That the state also submits that they were also not testimonial in nature. Therefore, because they were excited utterances and because they were not testimonial, that they violated none of the appellant's rights in this case. Concerning the excited utterance arguments, obviously the state is arguing that yes, they were excited utterances, and really of the 4-part test to determine whether it is an excited utterance, really the only element that's in dispute is whether the victim in this case was still under the stress of the excitement of the startling event that she had suffered, namely being choked, possibly even to unconsciousness. She wasn't sure of that. That's really the only element that's in dispute. And the controlling factor that this court has to look at when it determines did the trial court abuse its discretion in allowing this in, was whether the victim made her declaration under circumstances that would show that she made it from impulse rather than from reason or reflection. And in this case, unlike the Scala case that the appellant has mentioned today, the Scala case involved a written statement that followed in the police finding the victim running down the street. This case doesn't involve the victim's written statements. It involves her live statements to Officer Lagasse that were recorded not only through his recollection, but through his body camera video recording system.
Counsel, I understand that the state is arguing it is an excited utterance and it is not testimonial. The query I would have is, can a testimonial statement ever be an excited utterance?
Actually, yes.
Okay, under what circumstances?
Actually, thinking about that, come to think of it, actually I have to withdraw that and say not necessarily, I'm sorry. I
It's
misspoke.
okay, I mean, I have the question in my mind, so that's why we're,
Well, I was thinking that, I mean, obviously under the case law, whether a statement would be an excited utterance or would fit into some other hearsay exception or hearsay exemption is one of the things this court would have to consider when considering whether a statement is testimonial. And I think that's what threw me up at the moment. But if it's an excited utterance, that would tend to show the purpose for which the person actually made the statement. Because it's not the officer's statement in collecting the statement, it is the declarant's intent that is relevant as to whether something is testimonial or not. And because obviously not every encounter with a police officer results in a testimonial statement. So you have to look at whether, for instance, the declarant is seeking protection or seeking medical care. And for that, you would have an excited utterance where the declarant is saying, my gosh, I'm hurt, and here's who hurt me, and here's what happened, and it's all flowing out of the declarant. They're saying that to the police officer because they need help. That would be a non-testimonial statement that would also be obviously an excited utterance. But generally, I would say looking at what defines an excited utterance, if you have one, I think it would be extremely difficult to have it to be testimonial at the same time, simply because they, like I said, actually under both prongs of this argument, confrontation clause and hearsay, the intent of the officer isn't what's relevant. It's the intent of the declarant. And if the declarant is making the statement because they're still under the stress of the situation and it's out of impulse, they're not reflecting about it, reflection would be like, gee, what do I need to say to this officer because I want them to prosecute the appellant. Okay, that's not what's happening with an excited utterance. And that is not what the evidence shows happened here. And I know that's a roundabout way of answering your question.
no, you did a good job. I wonder though, on a different vein, just in case there is something in the record to help the court understand, why are we talking about this 2 hours later? Is there anything in the record? There might not be, that's fine, but is there anything in the record as to why 2 hours before we have an officer talking to the victim?
Alas, there is not.
Okay.
There's no real reason why the 911 call, by the way, it came in less than 90 minutes, actually. It came in at 5:17. The officer got there at 7 o'clock.
I'm not trying to,
Maybe not less than 90 minutes, but less than 2 hours.
yeah, I'm not trying to wipe into the situation, anything, I just wondered if there's anything in the record about that, so, and then you've answered the questions.
And, but again, that 2 hours or less than 2 hours, again, really isn't relevant to either, it's relevant to whether it's an excited utterance, but it isn't dispositive because There is a case that we had cited to in the state's brief. It was actually cited to in State versus Beasley. And that is State versus Connect. It's a 12th district case. In that case, there was actually a 6-hour gap between the startling event and the time when the victim called the police and the police actually showed up and talked to her. And that was still an excited utterance because she was still under the stress of that situation. She was still crying, she was still upset, she was still overwhelmed by the situation.
Should the court have considered her recanting in making the ruling on the motion, in determining whether or not it was an excited utterance?
Well,
Her recanting immediately might suggest that she was upset, just wanted this gentleman arrested, and marks on her neck to be consistent with the strangling.
that doesn't actually fit into the test, but it also would invade the province of the jury, because the jury gets to decide whether that excited utterance, like every other testimony and evidence, they get to weigh the credibility and also get to assign that statement its whatever weight they believe is proper. So,
The court should not have considered the fact that she recanted.
I guess the short answer is no then. So, no, I don't believe it would be appropriate. Besides, as a practical matter, as Officer Lagasse testified, this is a frequent occurrence, that the officers will go to the scene of an alleged domestic dispute. They'll be greeted by a victim who is still upset, who's still under the stress of the moment, who's showing them the red marks on her neck, and later on has a change of heart. And in fact, in the record, we do have evidence that this victim received at least one telephone call while Officer Lagasse was still there. And it was stricken from the jury's consideration, but he blurted out that he thought that maybe she had been persuaded in the intervening time between his visit and her calls to try to recant, that maybe she'd been persuaded to recant. So with that kind of problematic situation, the state would submit it's appropriate that is not part of the test to see whether someone has given an excited utterance. And again, the trial court though did have an opportunity, even with all that background, to review the video of Officer Lagasse in camera prior to the trial. You know, I believe it was on the morning of the trial, prior obviously to allowing it into evidence, and gave that due consideration and determined it was an excited utterance that would be allowed into evidence. And again, this was not the result of a formal interrogation by Officer Lagasse. He asked her what happened, asked her just the basic facts. That's something that officers are permitted to do. And per Judge Callahan's question, this was not a structured interview of the victim. But dovetailing with that, this also was not a testimonial statement that would have offended the appellant's confrontation clause rights. Because like I said, the focus is on the expectations of the declarant, not of police. And this is an objective inquiry, and this court, yes, this one is a de novo standard review, so this court must apply the same standard that the trial court applied, and that's an objective inquiry taking the totality of the circumstances into account. And the elements that this court would have to look at to determine whether it was a testimonial statement are very similar to the ones that the court has to review to determine whether it's an excited utterance. But this is really where the level of formality in Officer Lagasse's questioning becomes relevant. Here, this was in the victim's home, it was informal. Lagasse was permitting her to accept phone calls from other people and possibly even to continue drinking some intoxicating beverage. The victim's speech was a little slurred. She admitted she'd been drinking over the situation, and Officer Lagasse admitted that might have been an intoxicating beverage she had that she was still sipping on. So, but the state would submit that there was no error, either no abuse of discretion in admitting an excited utterance, and also no error in admitting it as a non-testimonial statement. Now, briefly, as to assignment of error 2, Judge Callahan, I would submit that you're absolutely correct that the state stated that it was not attempting to introduce the appellant's statements in his jail calls to get to forfeiture by wrongdoing. We would be introducing it if we were trying to introduce the victim's statements as being forfeited by wrongdoing. So we weren't trying, that would apply to the victim's statements, not to the appellant's statements. His statements got to his consciousness of guilt, and telling the victim not to show up to court was indicative of that.
Did they also play the victim's statements, the response?
Her responses were part of it, but the key was, what did the appellant say to the victim? And what did he have an agent, a fellow inmate, say to the victim? What was the pressure applied to her? Because we already did have evidence in the record that she had attempted to recant, on the night of the incident. So it also got to, putting that into context as well. And finally, both of those statements were admissions by the party opponent. Partly they were the appellant's own statements, and then the statements of an inmate authorized by him to call her.
And I understand that there were apparently a bunch of jail calls, but there's only 2 that were played in the state's case in chief that are at issue in this appeal.
That's correct.
Did the victim say anything in those statements that were, I use the word, say harmful? You shouldn't have choked me, or why did he choke me then, or he should not have put his hands on me? Anything that furthered the state's case in terms of proof of the domestic violence?
Not that I recall offhand, but I do know the point of introducing those jail calls was to show that the defendant was conscious of his own guilt, and that was why he was trying to keep the victim out of court and trying to keep her from essentially doing what she ended up doing, which was showing up, being on the stand, being strenuously cross-examined, and undermining his case.
So with respect to the admission by a party opponent, did he admit to the domestic violence incident in those jail phone calls?
Not that I recall, but you don't have to have actually an admission against your interest for it to qualify as an admission by a party opponent. It could be any statement, it could be the sky is blue.
Sure, but it kind of sounds like these were admissions of wrongdoing that would take us back into wrongdoing by trying to make her not show up, which would take us back into that whole scenario about whether or not we could have testimony of her out-of-court testimony admitted.
Well, only if that was the only avenue by which the state could bring in her statements, and that was not. Because we did successfully admit it under a different rule. So if the only way to have gotten her statements to Officer Lagasse admitted into evidence at the trial was by saying, okay, there's been a forfeiture by wrongdoing, then that would apply, but that's not the case. And
Actually, you've used all your time.
I was just going to say, I understand I've exhausted my time, and I thank you and urge you to affirm.
Thank you. Attorney Woods, you've got 3 minutes for your report.
Yes, thank you. Going to, I believe, Judge Teodosio's question as to whether or not the court considered her almost immediate act of recanting the night that she gave her statement In the trial transcript at page 30, Judge Gallagher, this is the day after I had made the motion for eliminate, he makes his decision and he says, I have reviewed the arguments of the defendant and the court is going to find that the statements made by the victim to the police officers through the camera are excited utterance and are admissible at trial, period. That's it. He doesn't give any reasoning. There's no further discussion. The rest of the transcript before the witnesses start with their continued argument on whether or not the jailhouse calls were going to come in. So under, cited in my brief, State v. Kratzer, part of determining whether or not an excited utterance should come in is the court is required to look at all of the facts and circumstances. And Judge Gallagher, it can be argued that he did not. He only looked at the tape and made a decision as to was she upset, were there marks. He did not take into the fact that she had recanted, and that was part of the argument that was made on behalf of the motion. Also, I'd like to maybe make a comment, and I'm not on the solidest of legal grounds with Judge Hensel's comment about whether or not there was an admission. It's still my contention that those jailhouse calls, the purpose of them being introduced was forfeiture by wrongdoing. And but Judge Hensel, you asked whether or not there was any admission, and there was not. There was not any. I don't know how you can have an admission by a party opponent when you're not admitting anything. He simply tells her, don't show up. He's not admitting guilt. He's simply, saying maybe not showing up. Maybe that's the best thing to do.
In his case, it sounds like that may have been the best thing.
Well, obviously he has a bias. He has an interest in having her not show up, but
Based upon
it's
the
still.
testimony turned out to be on his behalf.
But I don't know how you can take that call out of the context of you tell someone not to show up, and I've been in many trials where those type of statements and calls have come in, and it's under the forfeiture by wrongdoing evidence rule, and there was a notice of intent filed. So I don't know. I've made my argument. I believe that it was wrong to let it come in because that's why it was coming in. There wasn't any notice. I understand Ms. Corrigan's consciousness of guilt argument, and it's one that the court's going to have to decide as to what it was. Was it consciousness of guilt, or was it forfeiture by wrongdoing? I'll leave it to your discussion that you'll have after the oral argument when you're going to render your opinion. We're hoping that either on the first assignment of error, the second assignment of error, that you will find that there was a prejudicial error made, and you will reverse the conviction of Mr. Henning. Thank you.
Thank you both for your arguments this morning. The court will take the matter under advisement, issue a decision in due course. Of course, the clerk of courts will mail you each a copy of the decision on the day it's released. And as you both are aware, the opinions are also posted on the Supreme Court of Ohio's website. Again, thank you for your arguments.
Thank you.